calm down. We'll hear from the appellant.
Good afternoon, Your
Good
Honors.
afternoon.
If it pleases the court, I would like to reserve 5 minutes of my time for rebuttal.
That'll be fine.
My name is Ursula Bailey. I am a member of the Knoxville Bar, and I represent the appellate Ralph Moore in this matter. This is an appeal from a motion from the granting of a motion to dismiss. Would it be helpful to the court to hear some of the underlying facts?
Whatever you choose.
Your Honors, this case is an appeal from a motion to dismiss granted against Mr. Ralph Moore. Mr. Moore was a veteran who was visiting his wife at hospice at Specialty Select on February 24, 2018. At some point, he was awakened by Knox County Sheriff's deputies holding him at gunpoint, placing an AR-15 in his face, and shaking him awake. Mr. Moore had no idea what was going on. Apparently, a threat was called in saying that Mr. Moore had threatened people with a gun. Again, Mr. Moore, having been woken up, having no gun, had no idea what this was about. Mr. Moore was placed in cuffs, placed in a cruiser. Although he was never charged with a crime, he was injured. We filed suit 5 years ago today, February 14th, and on or about, in February 2022, the defendant's February 7, 2022, the defendant filed a motion to dismiss, citing, amongst other things, lack of subject matter jurisdiction. There was no response to the motion, and the court dismissed this case, granting the motion on March 24, 2022. There was a Rule 60 motion filed, which was never ruled upon, and this appeal followed 29 days later. The first...
Counsel, let me ask you before we get... do we have a final judgment? The motion you filed, the trial court hasn't ruled on, as I understand. Is that correct?
That is correct, Your Honor. But we could not wait another day.
Oh, I understand you didn't want to take the chance and the risk, but now do we have a final judgment, since it was what looks to me to be a Rule 5904 motion to alter or amend? So my question is whether or not we have jurisdiction over this appeal at this time.
Yes, Your Honor, the case was dismissed. There is nothing left for us to litigate in state court.
Except the motion is still pending, isn't it?
The Rule 60 motion is still pending.
Okay.
So I guess that places us in a precarious position. If this court doesn't have jurisdiction, who does? We can't go back and relitigate a motion because we would lose our appeal here. So we're forced to choose. Do we give up this appeal, or do we wait for the court to litigate? Well,
I think today we want, that's a question, at least I have, but we do want you to go ahead and address the merits too.
Thank you.
So if we decide we can proceed. But if we decide that we don't have jurisdiction, what that means is the trial court will have to decide, and whichever way they decide, the trial court decides, then the time for your appeal would not have run until the trial court decides. So I'm sorry, so go ahead.
Thank you, Your Honor. The trial court, in dismissing the motion, found that it did not have subject matter jurisdiction. We believe that this was an error. First of all, the plaintiff, Mr. Moore, was not given the opportunity to be heard. The trial court relied on the COVID plan, which stated that a party who was served with the motion after May 1st of 2020, I believe, had to respond within 30 days. However, the order also the plan also stated that the pleading must include the email address of opposing counsel. That was not done in this case.
Ms. Bailey, is that COVID plan still in place, or when did it stop being effective?
As far as I know, Your Honor, it's still in place unless it's sunsetted.
Okay.
But the Knox County did not fulfill their obligation under the plan, which is to include the email address of opposing counsel. And admittedly, the COVID plan is not clear. It only states that the email address must be included. It does not necessarily say that it has to be served via email. Whatever the case may be, none of that happened in this matter. So Mr. Moore proceeded, as we do in Knox County, waiting for a hearing date in order to know what his deadlines to respond were. Instead, we got a dismissal of the case, and as stated, it was appealed. Knox County would have this court believe that the COVID plan was a scheduling order, and they are trying to do this to get this court to look at the dismissal under an abuse of discretion standard versus a de novo. This was dismissed on lack of jurisdiction, and that is a dismissal on the merits, which requires a review de novo. The reason the court found that it did not have jurisdiction is the two issues raised by Knox County in their brief. One, that there are that you cannot have a suit for intentional torts in Tennessee, and that Knox County did not waive their immunity. And those two issues really go together because they're lumped under the Governmental Tort Liability Act. In this case, there were two intentional torts that were raised, one being assault and battery and one being false imprisonment without a mitimus. Those two intentional torts are not listed in the Governmental Tort Liability Act. Knox County has said that because Mr. Moore filed a federal law, or because he listed federal claims in his lawsuit, that he is now, that immunity has now been retained under the civil rights exception under the Governmental Tort Liability Act. While that is true in most cases, in this case, we have another vehicle to get those claims before the court, and that being 88302. 88302 was passed in 1970. The first version of the Governmental Tort Liability Act was passed in 1970. I'm sorry, it was passed in 1972. The first version of Governmental Tort Liability Act was passed in 1973, which means that 88302 was in existence when the Governmental Tort Liability Act, and it is presumed that a legislative body will know what laws exist when they are making new laws. And it is also common knowledge that one law cannot be passed that will conflict with another. There have been many other versions of the Governmental Tort Liability Act, the latest version taking place on July 1st of 2023. In each of those versions where the Governmental Tort Liability Act was changed, there was no change to 88302. The legislative body meant to leave that vehicle open for plaintiffs to be able to sue a county on the sheriff's bond. That is what we did here. When the court decided that he didn't have jurisdiction, he did not consider 88302, which was specifically listed in the complaint. So even if the court decided he did not have jurisdiction under the Governmental Tort Liability Act, the court ignored the fact that he had jurisdiction under 88302. Your Honor, there's other issues that have been raised, like a waiver, as I stated earlier, the trying to change the standard of review. Those are just red herrings that have been raised by Knox County because they know that a review on the merits of this case would not be successful for them. I ask this court to please remand this case back to trial court. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
May it please the court. Microphone is really right there, isn't it? My name is Houston Havasey. I represent all defendants or appellees in this action. Good afternoon. I want to address your question first, Judge Sweeney. There was a final judgment, and it contained the appropriate language to be a final judgment on March 24 of 2022. The motion that is unruled upon and was pending the time that it was aborted and appealed by the appellant as a Rule 60 motion. It's titled as a, yes, sir.
Was it filed before the notice of appeal was filed?
I'm sorry?
Was the motion filed before the notice of appeal was filed?
I believe it's undisputed. It was filed the day before. I'm sorry, it was filed much longer before the notice of appeal was filed.
Is it really a Rule 60 motion or a Rule 5904 motion?
I see your question. I think it is clearly a Rule 60 motion based off the subject matter that is within it. It tracks all the language required by a Rule 60 motion, which can only be filed after a final judgment. It tracks the language of mistake, inadvertence, neglect, fraud. The merits of the underlying Rule 60 motion that was aborted was based off a mistake. It was a mistake that didn't respond. I know a 59.04 would toll the time for appeal, but respectfully, it's our position that it was, as titled, a Rule 60 motion, and it contained the subject matter of a Rule 60 motion. And, of course, a Rule 60 motion would always have to be filed after a final judgment. It's only for review of a final judgment. I hope I answered your question satisfactorily. I'd like to begin where we have some common ground between the parties. The first common ground is that both parties agree there's one defendant in this action, Knox County. Many individuals were sued, but they were all sued in their official capacity, which is an action against the county, not the individuals. The other common ground we have is that both parties read the order the same, that the trial court dismissed this action on two reasons. The first is failure to comply with the COVID plan and respond, if you oppose a motion, to respond within 30 days. And then the second was the actual merits of the motion to dismiss. Focusing first on the COVID plan, which also brings us to our first disagreement, Knox County's contention is that the trial court's dismissal of this case is based on an abuse of discretion, that the COVID plan used the words may by the Tennessee Supreme Court and gave this discretion to all trial courts in the 6th Judicial District, that they could wait after 30 days after a motion was filed, rule without a hearing. And that's what gave the trial court's discretion. If you read the COVID plan, it tracks like a scheduling order, which is why I've cited a scheduling order language for abuse of discretion standards. It says, for these particular motions, do this. It says for summary judgment motions, do this. For motions to compel, do this. For trial, do this. And for those reasons, that's why I cited scheduling orders language as to the law on abuse of discretion.
In your response in the trial court to the motion, I mean, did you basically say, well, you have no objection to plaintiff's Rule 6002, excusable neglect, to the extent the order relied upon the COVID plan noncompliance?
I believe I did, Your Honor. I think that's a quote.
Yeah, I think it is a quote.
I think that's a quote. And, the merits of the Rule 60 motion are rather strong. The problem with it is that the appellant aborted that motion procedurally and appealed, divesting the trial court of subject matter jurisdiction to rule any further. And now we're before this court, and procedurally, I don't want to tell anybody what to do or how they practice. I think the law that we've provided shows that the appropriate way to have maybe handled this is to ask this court for a remand under, I'm going to say Gideon, but I don't think that's right. Eidson, E-I-D-S-O-N versus City of Portland, August the 3rd, 2018, that would have been the appropriate way to deal with this, if it in fact is a Rule 60 motion as we contend. And they did not do that. So now we're here, and I've asked this court to strike from the record any of those post-judgment filings, because this is an appellate court, and the trial court did not rule on any of those post-judgment filings. And for that reason, I don't think it's appropriate this court weigh in on the post-judgment filings. I do want to address what I believe is a mistake from the appellant, that they contend that Knox County did not comply with the COVID plan by placing its email in the motion to dismiss. It's in the technical record on page 21. It's in the signature block, my signature block on the motion to dismiss. It's right at the bottom of my signature block. My email address is there. So now, secondly, I think they've abandoned the fact that we needed to serve them by email. The COVID plan says no such thing. It only says that we had to serve by email under for motions to compel, which this was not. So the second and complete different reason this case was dismissed by the trial court was based on lack of subject matter jurisdiction. And we have gone through painstakingly the reasons why, under the GTLA, you cannot sue a municipality in the state of Tennessee for an intentional tort under the GTLA. Not to be conflated with 88302, which was just mentioned, which is not a vehicle to bring the same claims in under 88302. Rather, 88302 is a separate, independent cause of action against counties. So you can't, for example, bring a false arrest or some other claim and wedge it into an 88302, but rather you bring an 88302 claim itself. We cited Limbaugh versus Coffee County. I feel like we cleared up that confusion as to why intentional torts are not permissible under the GTLA. We brought up and raised the civil rights exception.
Help me here, because I'm still confused. Why under 88302 just to bring anyone incurring any wrong, injury, loss, damage, or expense resulting from any act or failure to act on the part of any deputy appointed by the sheriff can bring suit against the county in which the sheriff serves? But
yes, sir. Yes, sir. I read that as an independent cause of action, and the cases, which I love this claim as a plaintiff's lawyer. I used to use it all the time. It has a statutory cap, maybe not statutory. It has some type of cap of $100,000 as opposed to a GTLA, which has a cap of $300,000, which makes the GTLA more attractive to plaintiff's attorneys to raise. But an 88302 claim is a separate and distinct claim. It is not part of the GTLA. It is a completely different vehicle to remove immunity from a municipality.
was it raised in the complaint?
No question, Your Honor. It absolutely was.
It was?
Yes, sir.
803, okay.
Yes, sir. So, again, trying to focus again on the GTLA and why all the claims, the exception of 88302, should be dismissed for lack of subject matter jurisdiction. Limbaugh, intentional torts under Limbaugh says they're not appropriate. The civil rights exception, which is Cochran and its progeny, says that when you look at the gravamen of the complaint, and if it smells like civil rights, you can't pursue it under the GTLA. And then the third reason is that the magic language of pleading negligence in the course and scope of an employee's employment has to be, those magic words have to be in there. It's jurisdictional. Brandon versus Shelby County, citing Gentry, has made clear that you have to plead those words exactly, or the legislature has not removed immunity under the GTLA. Course and scope of employment are not in the complaint, neither is the word negligent or negligence. So to address finally 88302, our first contention is why you should uphold this is that the dismissal of that statutory claim is that it was only raised in a cursory or skeletal way in the appellant's brief. It was not raised as an issue, and I think we raised that in one of our first three issues. The second is that the dismissal should be upheld based upon the COVID plan, that the trial court had discretion. After 30 days, anyone, if you look at the COVID plan, it says anyone who opposes the motion must file a response within 30 days, or something to that effect. I'm paraphrasing. In essence, the appellant is not opposing the motion, and the trial court correctly invoked its discretion and it dismissed the 88302 claim. For those reasons, we ask that you uphold the dismissal of that claim as well. Still have some time left, Your Honors, but I'm happy to answer any questions if you have anything for me.
I hear none. So, thank you.
Thank you all.
We hear from the appellant rebuttal.
Very quickly, Your Honor. First, a point of clarification. Appellee stated that they complied with the COVID plan by including their email in their motion. The language of the plan is for the email address for all attorneys or record. I guess it should say of record, but it says or record, or pro se parties. That did not happen in this case. Second of all, under 88302, they are admitting that that is a viable claim. And that in and of itself gives the court subject matter jurisdiction. So I don't know what the issue is. Additionally, they said that GTLA is not a vehicle because it excludes intentional torts. It does not exclude all intentional torts. So it is a vehicle, had we choose to use it as a vehicle. I think that a lot of people see the GTLA as a vehicle to sue. I think it is more a matter of immunity or to retain immunity for the governmental for the governmental entity. And finally, as far as not responding, even if we did not respond, the trial court still has to follow the law. And he cannot find that he didn't have jurisdiction when he did. Again, we ask that this case be remanded back.
And our thanks to both sides. We appreciate your briefs and your oral arguments today.
Thank you.
If you would, please recess court till tomorrow morning.
All rise. This court stands adjourned.